Hello everyone, how are you all? I hope everyone is fine and safe and everyone is keeping very happy and safe home. Yes, so then let's start our video. See, now we have been doing various concepts on law. We have been discussing what law is, what is the function of law, types of laws, and differences between various types of concepts that we have in law. But in this particular video, we are going to do the details, that is, starting from what a consideration is, who can contract, and various examples we are going to discuss. And we are also going to discuss the legal principles related to civil law. Okay, so this is what our agenda is. So starting with the video today, what is consideration? You see, if you study law or if you have subject in your examination, you will be accustomed with this word consideration. So Section 2D of the Indian Contract Act defines consideration as when, at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do so or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. So this definition requires the essentials that is required to be satisfied in order to have a valid consideration. So let's consider what needs to be satisfied. Firstly, consideration is to be given at the desire of the promisor, right? So if that is so, consideration is also to be given by the promise or any other person. Consideration may be past, present, or in future, insofar as the definition says that the promise has done or abstained from doing, or does or abstain from doing, or promises to do or to abstain from doing something. And also, there should be some act, abstinence, or promise by the promisee which constitutes consideration for the promise. So this is all in related to what a consideration is. Now coming to the word contract, you might have heard the word contract. So what a contract is. One of the essential of a valid contract mentioned in section 10 is that the parties of the contract should be competent to make the contract. Now, what is written according to section 11? According to section 11, every person is competent to contract who is of the age of majority according to the law to which he is subject and who is of the sound mind and is not disqualified from contracting by any law to which he is subject. While studying this, do not forget there are three categories of person who are not competent for a contract. Firstly, a person who is of unsound mind, a person who has been disqualified from contracting by some law, and a person who has not attained the age of majority. That is the person who is a minor. Although the points that I said, the categories of person are not competent for contract, yet they may be sometimes by making some bargains, taking some loans, or be supplied with some goods by third parties or be conferred with some benefits. So what is a free consent? Coming to the definition of free consent, what is it? One of the essentials of a valid contract mentioned in section 10 is that the parties should enter into the contract with their free consent. That means no force should be done. According to section 14, consent is laid to be free when it is not caused by coercion as defined in section 15 or undue influence as defined in section 16 or fraud as defined in section 17, or misinterpretation as defined in section 18. Also, mistake subject to the provisions of section 20 and 21 and 22. That is section 20, 21 and 22. Next, consent is said to be so called when it would not have been given, but by the existence of such coercion, undue influence, fraud, misinterpretation, or mistake might happen. If the consent of one party is not free consent, that is, has been caused by other or one of the stated factors that I told you, the contract is not a valid one. That means without the free consent, the contract is not considered valid. When consent to an agreement is caused by coercion, undue influence, fraud, or misinterpretation of the agreement, is a contract voidable at the option of the party whose consent was so caused. If, however, the consent is caused by mistake, again the agreement stands void. Now, there's a important thing. Sometimes we have a question: what consideration and objects are lawful and what not? The consideration or object of an agreement is lawful unless, keep in mind the following points that I'm going to say: it is forbidden by law, or it is of such a nature that if permitted, it would defeat the provisions of law. It is fraudulent in nature. It involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. In each of the cases that I have discussed, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. Now, discussing all these things already, I will give you some idea of, actually I'll give you some examples and we can discuss as to what stands void, what is lawful consideration and which is not. Let's take an example. Mr. A agrees to sell his house to B for rupees 10,000. Here, B promises to pay the sum of rupees 10,000. It is the consideration for A's promise to sell the house. And A's promise to sell the house is the consideration for B's promise to pay rupees 10,000. These are lawful considerations. Again, I'll give you an example. A promises to pay B rupees 1,000 at the end of 6 months. If Mr. C, who owes the sum to B, fails to pay it, B promises to grant time to C. Accordingly, here the promise of each party is the consideration for the promise of the other party, and they are all lawful considerations. Another example, again with Mr. A and B. A promises for a certain sum paid to him by B to make good to B the value of a ship if it is wrecked on certain voyage. Here, A's promise is the consideration for B's payment, and B's payment is the consideration for A's promise. And these are lawful considerations. Giving you another example, A promises to maintain B's child, and B promises to pay rupees 1,000 yearly for the purpose. Here, the promise of each party is the consideration for the promise of the other party. They are also lawful considerations. Illustration number 5, giving you another example. A, B, and C. They enter into an agreement. Let's consider A, B, and C entering into an agreement for the division among them of gains acquired or to be acquired by fraud. The agreement is void. as its object is unlawful. Okay, I'll give you another example. A promises to obtain for B an employment in the public service, and B promises to pay rupees 1,000 to A. The agreement is void, as the consideration for it is definitely unlawful. Moving on to another example. A, being agent for a landed proprietor, agrees for money without the knowledge of his principal to obtain for B a lease of land belonging to his principal. The agreement between A and B is void, as it implies a fraud by concealment by A on his principal. Got it? That's considered as fraud. Giving you another example. A promises B to, let's consider, drop a prosecution which he has instituted against B for robbery. And B promises to restore the value of the things taken. The agreement is void as its object is unlawful. Another example I'll give you. A's estate is sold for arrears of revenue under the provisions of an act of the legislature. By this, the defaulter is prohibited from purchasing the estate. B, upon an understanding with A, become the purchaser and agrees to convey the estate to A upon receiving from him the price which B has paid. The agreement is void, as it renders the transaction in effect a purchase by the defaulter and would so defeat the object of the law. So that's why it would be considered void. Again, I'll give you another example. Let's consider A and B. A, who is B's Muktar, promises to exercise his influence as such with B in favor of C. And C promises to pay rupees 1,000 to A. The agreement is void because the purpose is immoral. I'll give you another example. A agrees to let her daughter to B for concubinage. The agreement is void because it is immoral, though the letting may not be punishable under the IPC. That's Indian Penal Code. Okay, so all such examples being given to you all, you will be able to understand or consider or the object has been considered to be unlawful or lawful as per section 23. And as per section 23, it's unlawful if it is forbidden by law. It would defeat the provisions of any law. It is fraudulent. It involves or implies injury to a person or property of another. The court regards it as immoral, or the court regards it as opposed to public policy. So these are the illustrations that we have discussed. I hope you have understood well enough. So if this is clear to go, then we'll proceed to the next thing I have in my mind, that is legal principles of civil law. Okay, in the previous video, we have discussed about the criminal law, and in this video, we are going to discuss about the civil law. Now, before we move to the civil law, please have a recap of the criminal law that was done in the last video, so you can have a clear idea. So there are various number of principles that we have for civil law. It's almost 24. Okay. Yes, we'll discuss everything one by one. So legal principle 1. What does that state? Then, at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing or promises to do, or to abstain from doing something. Such act or abstinence or promise is called a consideration for a promise. Moving on to legal principle 2. contract obtained by misinterpretation is voidable at the option of the buyer. Moving on to legal principle 3. A contract procured by coercion is bad under Indian Contract Act. Is defined as committing or threatening to commit an act forbidden by Indian Penal Code. Attempt to commit suicide is an offense under Indian Penal Code. Moving to legal principle number 4. A contract without consideration is void when, at the desire of one party, the other party does something. The consideration is said to flow from the later to the former. Moving on to legal principle number 5. A contingent contract is a contract to do or not to do something. Is some event collateral to do the contract does or does not even happen. Moving on to legal principle number 6. When there is a breach of contract, the resulting damages will have to be paid by the party. Breaching the contract to the aggravated party, however, the parties are free to agree as to the damaged payables in advance in case there is a breach of contract. Moving on to legal principle number 7. A right of action cannot arise out of an illegal activity. Moving on to legal principle number 8. Damages are payable for breach of contract, and the purpose of damages is to compensate him or her for the loss suffered and not to improve the position more than what it would have been if the contract had been duly performed. Moving on to legal principle number 9. When the parties to an agreement agrees on the same thing in the same sense, there arises legally binding obligations between them. Moving on to legal principle number 10. The act of using threats to force another person to enter into a contract is called coercion. Be very careful with this word. Do not have confusion with coercion and extortion. That's different. The act of using threats to force another person to enter into a contract is called coercion. Moving on to legal principle number 11. The act of using influence on another and taking undue advantage of that person is called undue influence. Legal principle number 12. In order to prove coercion, the existence of the use of threat in any form and manner is necessary. If coercion is proved, the person who has been so threatened can refuse to abide by the contract. Moving on to legal principle number 13. In order to prove undue influence, there has to be a pre-existing relationship between the parties to a contract. The relationship has to be of such a nature that one is in a position to influence the other. If it is proven that there has been undue influence, the party who has been so influenced need not enforce the contract or perform his obligations under the contract. Moving on to legal principle number 15. A minor is a person who is below the age of 18. However, where a guardian administers the minor's property, the age of majority is 21. Next, coming to legal principle number 15. A minor is not permitted by law to enter into a contract. Hence, when a minor enters into a contract with a major person, the contract is not enforceable. This effectively means that neither the minor nor the other party can make any claim on the basis of the contract. Moving on to legal principle number 16. In a contract with a minor, if the other party hands over any money or confers any other benefit on the minor, the same shall not be recoverable from the minor unless the other party was deceived by the minor to hand over money by any other benefit. The other party will have to show that the minor misrepresented her age, he was ignorant about the age of the minor, and that he handed over the benefit on the basis of such representation. Moving on to legal principle number 17. A minor is not competent to enter into a contract, and the law will assume that the contract never happened and everything is returned to as it was. Moving on to legal principle number 18. An agreement, the meaning of which is not certain or capable of being made certain, is considered void. Moving on to legal principle number 19. An agreement is void to the extent that it restricts absolutely a party from enforcing his contractual rights by using proceedings in the ordinary court. Moving on to the next principle, legal principle number 20. Every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind to that extent is considered void. Moving on to legal principle number 21. The object of an agreement is lawful unless it is forbidden by law, is of such a nature that, if permitted, it would defeat the provisions of the law, of any law, is fraudulent, involves or implies injury to the person or property of another person, the court regards it as immoral and it is opposed to public policy. Moving on to legal principle number 22. Where both the parties agree to an agreement are under a mistake as to a matter of fact essential to the agreement is void. Moving on to legal principle number 23. An agreement becomes a contract when it is entered into between two or more people with each other's free consent. Two or more people are said to consent when they agree to the same thing in the same sense. Consent is said to be free when it is not caused by coercion, undue influence, fraud, misinterpretation, or mistake. Coming to the last legal principle of the civil law, that is legal principle number 24. A contract requires a proposal and an acceptance of the proposal. It is necessary to make a binding contract, not only that the proposal be accepted, but also that the acceptance is notified to the proposal. Right? So I guess all the legal principles of the civil law have been clearly understood. Right, so in this video, we have discussed few important concepts as to what is a contract, what do you mean by consideration, what is free consent, and I have given you various examples. Also, we have discussed all the legal principles relating to the civil law. If you want to follow the other videos made on law, do follow the previous ones. And definitely in the future videos, we are going to discuss various other concepts relating to legal reasoning or law. So thank you for watching me out and all the best for your career ahead. Thank you so much.